I now request Ms. Nikita Panse, Associate and Hamish Lal Partners, moderator for session 4. Can we have on the stage Mr. Amit Pekam, Senior Director, FTI Consulting, Mr. Andrew McKenzie, Partner and Regional Head of Litigation and Arbitration at DLA Pipers, UAE, Ms. Gunjan Chhabra, Partner at MRP Advisory, Mr. Unmesh Kulkarni, Senior Vice President, Contracts Administration, Shapurji Palonji. I would now request Ms. Panse to please commence the session.
Good afternoon, everybody. Welcome to the panel discussion on the role of delay experts and methodologies of delay analysis. I will be acting as the moderator for this panel, and it is truly an honor for me to be here today. In every international construction arbitration, delay, and more importantly, cause of critical delay, is the key battleground. Now, we've heard a bit today about delay experts and the number of methodologies available to analyze delay. But here to tell us more about it are 4 very distinguished panelists. Before I introduce them, I would like to share the program for this panel briefly. I will begin by introducing each panelist. We're then going to dive directly into a very interactive session where I will be posing some questions to the panelists. Hopefully, we will have about 10 minutes left where we can address some of the questions from the audience. And I'll try my best to be brief and ensure that the audience also gets a chance to ask questions. Our first speaker today is Mr. Amit Pekam. Amit is a director at FTI Consulting and leads the construction, projects, and assets practice in India. He's a testifying delay expert with more than 18 years of experience in the construction industry and more than 6 years of experience as a delay analyst and expert. Welcome, Amit. Our second speaker is Mr. Andrew McKenzie. Andrew leads the Tier 1 ranked dispute resolution practice for DLA Piper across the Middle East. He specializes in construction, engineering, and energy disputes, and is a qualified English law barrister, solicitor advocate, and arbitration law specialist. Andrew, welcome to today's panel. Our third speaker is Mr. Unmesh Kulkarni. Unmesh is the Senior Vice President of Contracts Administration at Shapurji Palonji and Company. He has over 34 years of experience in managing contracts and disputes related to the energy and infrastructure sectors. Welcome, Unmesh. Our fourth speaker is Ms. Gunjan Chhabra. Gunjan leads the dispute resolution practice of MRP Advisory in India. She's a dual qualified legal professional, admitted to the Indian bar and enrolled as a solicitor in England and Wales. Her specific expertise lies in high-stakes construction disputes before local courts, domestic tribunals, and international arbitral tribunals. Welcome to the panel, Gunjan. Let's begin today's discussion by my first question to Amit. So, Amit, in the Indian construction industry, what, according to you, are the specific, unique challenges that delay experts face? And in your experience, do you think that the Indian context demands some specific delay expertise?
Right. Thank you, Nikita. The challenge which I would say is faced in Indian industry is not very unique to India, records being the one. But what I typically find in Indian industry is the records are inconsistent. And I'm trying to, when I try to think about why that causes, what causes that, there are 2-3 issues that come into my mind. One is, Indian industry is dispute averse. They don't want to get into dispute. They want to resolve the disputes amicably. And this is similar approach even the Japanese contractors have. But the difference between the two is, even though Japanese are dispute averse, they still maintain a very good record. And there is rarely there is inconsistency in the different types of records. For example, DPR and MPR will marry each other. The progress reported in the MPR would marry with the Primera program as well. But that is not what you see here. And then I ask myself why that's happening. And based on my experience, is when the Indian contractors consider that we don't want to be adversarial with our employer and we want to be a collaborative, they tend to ignore the record keeping at all. And what that leads to is, at some point in time, whenever the situation demands, there is a lot of pressure from the management to create the records, and at times, those records are ignored. For example, I know that many of the contractors here, when they are appointed, they invest significant amount of time and efforts to create the program. But then it's absolutely ignored when the project runs smoothly and there are no issues. And those records are only looked at again when there is a delay event which has gone out of hand. So that's the typical trend that I'm seeing, and which, as a delay expert, I face that as a challenge, because then I'm faced with a situation which record to rely on. So the root cause of this is, I think the planning and record keeping is not given its due diligence in the contract management and project management phase. That's where I think, one of the key challenge which I face. And in terms of, other issue that I face is the perception of an expert's role. So, of course, experts are seen as a expense. There is no denial about it. But then, Indian industry probably, why it differs is that internationally, experts are approached at a pre-dispute stage, even at the claim preparation stage, to give a valuable input as to what could be the reasonable case for them. Whereas here, I find that most of the times, experts are hired at the end of the negotiation process when most of the situation has gone out of hand. And then there is an expectation that the expert should toe the line what the client want to take.
But that's a very interesting point you've raised, Amit. Thank you so much for that, because it gives me a really brilliant segue into my second question, which is for Gunjan, which is that from a council standpoint, do you think that there is an optimal time to engage a delay expert specifically? And if you do believe that, could you tell us what are the risks if the engagement occurs later than what you think the suitable time is?
Nikita, thank you so much for that question. And to answer that question, I'm going to sort of take cue from what Mr. Pekam has already stated. So I would say that as a council, I would advise using delay experts not as firefighters, but sort of architects of the entire narrative of the causation of the case.
Right.
And why I would say that is because essentially what happens is if you have a delay expert involved from the stage when you're anticipating a delay, so not ex post facto,
right,
but when you're seeing that there is a delay which is going to be caused in the project, that's when you have your delay expert on board. And what that does for you essentially is, number one, your delay expert gets to sort of control the narrative. So you're going to have your contemporaneous records in place, and there's going to be minimalistic loss of evidence with the involvement of the delay expert from day one. And number two, what that's also going to do is that your claim notices, whatever contractual requirements are there for sort of being in line with the contract and enabling you to have a claim at a later point in time, is also going to be fulfilled because there's going to be a delay expert involved right from day one. And what also happens is, if you don't involve a delay expert right from that stage, as per my understanding, is the exact opposite. So you risk essentially loss of evidence. You run the chance of not having contemporaneous records when the delay expert comes into the picture. And then you have a delay expert essentially scrambling all over the place, sort of a thing, and trying to build a narrative of things which have already happened. So he's now acting from a place of reaction instead of helping build the case. So as per my understanding and in my opinion as a counsel, the delay expert's role has to be used as a strategic armor and not a firefighting mechanism. And if they're engaged too late, they're left to sort of douse the flames with half a hose, if that makes sense.
Yeah.
So yeah, that's my opinion.
No, that's a very interesting perspective. But now that we've heard from the delay expert about this and from the council, I'm very interested to learn, Mr. Kulkarni, what's the in-house opinion on this? Is this something that clients generally do consider? And if they don't, why not?
Okay. I carry forward the conversation from both of my earlier speakers. Basically, it is a fact that it is looked as a cost.
Right.
Okay. Now, as each contractor performs variety of projects, depend upon the magnitude, risk, and complexity, the involvement of the delay experts or in-house delay preparators in the beginning are being used. The expert guidance are being taken sometime on call basis or on the regular basis. It is a practice at least in the leading construction companies. But having said that, if I look at a B-tier contractor and below, no, what Gunjan has said is a fact. Majority of the time it is looked at only a firefighter. Rather, the delay expert is brought on the board once the arbitration notice has been issued.
Right.
And then it's expected that he will bring a miracle with the data what is available. And sometimes it happens other way around, because if the other side have a little better records and the delay experts make something, I'm using a word, fabricate something, I'm purposefully using the word, it bounced back adversely.
Thank you. Thank you for that. So my next question is for both Andrew and Gunjan. And Andrew, if I could ask you the question first. So from a counsel's perspective, have you ever had a situation where you need to convince the tribunal of the delay expert's relevance and credibility? And how would you deal with such a situation?
Thank you, and thank you again to the SCL for organizing what is a fantastic conference. Before I answer the question, I always like to make sure the audience is paying attention and awake, especially on a topic like delay. Can I just do a straw poll? How many in the room are lawyers or legal counsel? It's about a third. And how many are experts, either delay, quantum? Okay, probably about another third. And so those of you who didn't put up your hand, I'll assume you're either in-house or involved in the construction industry in some other way. One of the core issues, going back to the question, is about credibility. And if you lose that, or rather the expert loses that, you are then fighting an uphill battle. And to borrow a very good analogy earlier, you're then suddenly finding yourself with no hose to douse the fire that you found yourself in. What I find fascinating is that the experts themselves are often not necessarily the root cause of that credibility being lost. It's sometimes the counsel. We saw this actually in a case last year in the TCC courts in England, Glover versus Fluid Structural Engineers. Those of you might be familiar with the case. It wasn't the experts that had ruined their credibility. It was the lawyers. It was the lawyers' digital fingerprints on a joint report that had passed between the experts and was disclosed back and forth. And what the other side's counsel discovered was track changes embedded by the lawyers themselves, which of course was hugely embarrassing, not just for the expert, because his own report had been changed by the lawyers, who pleaded, oh no, they were simply just aligning his report or his comments on the joint report to make it more pleading friendly. That was dismissed by the judge, Justice Lofthouse, who was sitting in that case. He actually ended up having the expert removed from the proceedings. It was a request by the claimants who found themselves in sticky water. But ultimately, because the expert wasn't strong in their self and their independence and rebutting the counsel. And we all, don't get me wrong, as lawyers, we all want to try and control things as much as humanly possible. But ultimately, there is a point where you have to take a step back and trust the expert and not play around with their, ultimately with their independence just because you want to exercise your control freak tendencies.
Thank you. That's a very interesting perspective. Gunjan?
Thanks, Nikita, and thanks, Andrew. I'll again take you from what you've already stated. So I think, whenever sort of the tribunal is unconvinced of an expert's report, inevitably there's going to be an expert on the other side as well. So a good strategy would be sort of to start with discrediting the other side's report. Okay. And how you would do that is essentially on, all of these bases. So you look at the assumptions that the expert's taken. You sort of attack the credibility and the independence, probably going to the digital signature. And the independence also sort of reflects in the kind of analysis that the expert would have undertaken. What is the kind of documents that he's reviewed he or she has reviewed in his expert report or her? And is it sort of a one-sided expert report? Is it only meant to be supporting the lawyer's narrative? Or are there areas of concurrence where you do see the experts meeting minds? So, those are some of the areas where you could discredit the other side's report. And similarly, after you've sort of finished doing that, you could then move on to your expert and comparatively show what are the advantages of relying on your expert's report. And that's how I would build sort of credibility and relevance as to my expert's report. Having said that, I've also come across some scenarios where tribunals are just not convinced of the use of experts in the first place. Mm-hmm. And how I feel like that is a more strategic move to be making. So when your expert's report is being prepared, the only thing you can guide the expert to do is to make it in a fashion which would be understandable to the tribunal. So it should be in a language which the tribunal understands. So if, for example, if it's the tribunal which is completely from a technical background, you model and guide the expert in a way that please prepare your report in a manner which is more technical in nature and understandable by the tribunal. And right. Similarly, if it's a completely legal tribunal and they don't have a background in construction or infrastructure disputes, and your report is essentially speaking on, say, technical aspects or something of that sort, then you guide the expert that, okay, look, your report should be more simplistic so that it breaks down the technical aspects for the tribunal. And that, in a way, is an excellent way, in my opinion, to convince the tribunal that, this is somebody you can rely on. They're here to sort of assist you make a good decision. And yeah, that's how I have gone about it in the past.
Thank you. Thank you for that. Mr. Kulkarni, my next question's for you. From an in-house perspective, when you're drafting and negotiating a contract, what should one keep in mind when it comes to provisions relating to EOT, delay, program, etc.?
See, if you are going to bid for a government contract, then those opportunities are very limited. But right in the morning, our eminent guests have said, they also need to be open in mind, keeping the latest trends, latest requirements in mind. If that opportunity exists, then fair and reasonableness, which is actually expected, determination timeline is something which is exactly has to be there, because majority of the contracts talks about within how much time and contractor need to submit his request for extension of time or how we submit his program. But the reciprocation of that in form of an approval or consent, timelines are never given.
Right.
That's one part. Second is methodology in which a baseline program need to be submitted, how an updation need to be submitted. If you happen to change your construction concepts at the program stage versus actual construction stage, which is a fact,
right,
is never been captured. And contract remains silent on all these aspects. So more you keep it vague, more will be the problems. More clarify you will be in the contract, better will be the contract administration or life cycle phase. And as Amit has said in the beginning, as typically Indian contracting organizations are not litigation savvy. They do not want to have a litigations at first place. So in order to make those attempts of resolution, if there can be an inward looking approach of all the stakeholders, be it the engineer or PMC, the employer and a contractor, then certainly the solutions can be drawn. than looking outward and simply sending that, okay, provisional extension of time granted, or interim extension of time with leaving damages, right for damages, etc., which can be a good way to begin with.
Right. So, Amit, in your experience, I know that you've worked a lot as a testifying expert. One thing that's always been a question for me is, whenever a tribunal wants to do some sort of case management and asks the two experts who are party appointed to agree to some kind of joint expert report, have you, in your experience, felt that that's been a fruitful exercise where you've really been able to agree to some common issues that are going to help the tribunal? So in your opinion, is that a step that is worthy of being included in the arbitral proceeding? And I'd also like Andrew's input on this topic from a counsel perspective.
Thank you, Nikita. From my experience, yes, definitely, joint expert report does add value, but also it depends on how the other side expert is, how independent and objective he is. Where I have seen, even in a delay perspective, it is very rare, but I have seen in one of my cases, we have agreed on critical path on 80% of the time, which is huge in terms of delay, how the delay disputes happen. But yeah, when there is an objectivity involved, then definitely this happens. But then, I have seen the experts where they make use of the silence in the Society of Construction Law protocol. For example, SCL doesn't define what does it mean by critical path. So if that's the case, then one says, okay, the least progress item is critical, and the other says the activity having zero float is critical. So one uses quantity-based analysis to define critical path, and the other uses the network path analysis. And that becomes an area of dispute where, as a planner, it will be straightforward and simple concept, but then that becomes a huge disputed segment. So that's what has been my experience, that joint expert report does add value. It narrows down the frivolous areas of dispute. It roots out the frivolous issues and focuses the party's attention on the very substantial matters. Andrew.
I would agree with that entirely. I think early engagement on this topic can save so much time.
Right.
So both as acting as counsel, but I also occasionally sit as an arbitrator, I find the driver for this engagement changes slightly. As an arbitrator, as part of a panel or as a sole arbitrator, I want to see that early engagement. I usually prescribe it in the procedural timetable to say that the experts, the delay experts, should not only be appointed, but they should meet even before the pleadings are served to start formulating a view as to what form of analysis they're going to adopt and reach agreement. And if they cannot reach agreement on that, they need to set out why. But as counsel, you're often having to juggle a lot of different things, including cost. And your clients are very keen not to incur costs unnecessarily. And sometimes the strategic pressure is that you want to get the pleadings done so you can see if the parties can meet somewhere in the middle and ultimately stave off the rest of the proceedings and bring about a settlement. And as a result, you tend to kick the can down the road, not because you want to. Trust me, as a lawyer, I would much prefer every single delay and quantum and engineering expert to be on board from day one or even before we're approached. But what often happens is you get phoned by a client. They said they've just received a request for arbitration or they've issued one themselves. The clock starts ticking and you're scrambling around to find the evidence, put their case together, get the statement of claim ready or the defense and counterclaim. So it should always be a priority. And I'd like to see more and more tribunals making it a priority. There's one in the Middle East, Alec Emerson, who many of you may know. He insists it's usually the third or fourth agenda item on the CMC that the experts meet. The parties have to declare what experts they're planning on appointing, that their analysis is agreed in advance, and then ultimately that they meet to formulate a view on delay. The problem with the critical path, and I agree entirely, it should be something that's not controversial. The critical path should be pretty easy to identify. But I've just finished a sort of $2.5 billion dispute in the Middle East where there were clearly two aspects to the project. In fact, they were separate projects. They were just covered by one core contract. And neither party could agree whether there was sectional critical paths or one global critical path. And both parties were, and indeed their experts, were at each other's throats over the issue. So regardless of what we think is common sense, often takes a back seat when parties are at loggerheads.
No, thank you for that. Thank you. And Andrew, while I still have you, we've heard in this previous panel some very interesting discussions on AI, on how they're contemporaneously gathering the data, probably changing its form. I think LR spoke about drone data. So in your experience, do you already see a lot of such type of digital evidence being submitted in international arbitrations? And do you think that there are any admissibility issues specifically that we need to keep in mind for such evidence?
Absolutely. This is a really, really exciting topic. About maybe 10, 15 years ago, I remember doing a very large dispute in Doha where the idea of a 3D model was mooted to show the progress of the project. It was a mixed-use development, 5-star hotel project. And this was considered cutting edge at the time, which is I kind of laugh at now because you can get AI to generate these models very, very quickly nowadays. But yet tribunals are still quite reluctant, even now, to embrace additional data that they don't fully understand. I found the last panel fascinating, and a comment by one of my ex-colleagues, Shurav, who talked about the arms race. I think there is an arms race coming, and I think contractors and subcontractors who embrace what is nominally called the Internet of Things to track their projects are going to be at an advantage in that race. So we saw an example staying in Doha, in fact, on one of the major stadium disputes after the World Cup, where the delay analysis was, a part of the evidence that was presented was drone footage of the site. And that was, it was mentioned in the award, was decisive for the tribunal in determining that the employer caused a large claim delay, because the drone footage showed that the blackout period affecting the cranes was employer-led, not contractor. And without that evidence, the tribunal said they were still uncertain. So there was a clear example of where drone footage was used. There's a Canadian case where they used a 3D BIM model that effectively showed the development of, or the impact, I should say, of the late arrival of the structural steel on a large-scale project. In addition to that, there was and again, the court in that case said it was decisive and very illuminating in relation to the pleaded case. Last year, there was a study done that surveyed about 150 arbitrators who said about 70% of them said that they find this type of evidence, whether it's drone footage, statistics and data taken from wearable tech, like your Apple Watch tracking the number of people on site. There's also various things you can attach to hard hats and various other things. They can track everything from the temperature on site, vibrations, concrete curvature data, all of this stuff. 70% said they found it very helpful and indeed persuasive, but they needed it to be confirmed independently. And that's where this idea of whether this evidence can be admitted into the proceedings the debate rages. So in England, it has to be material and relevant and backed up by usually by a technical expert. Here in India, I'm reliably informed under the evidence law, I think it's 65B, they need a certification. It's a formal process. The DIFC and the ADGM, where I tend to do most of my work in for arbitration as well as courts, they have a similar process to that, but it's not as formalized. And Singapore, I believe, follows the English mentality as well. So when we're advising clients about this, there's sort of a number of practical tips that we always recommend they adopt. Early collection, which was said by one of my co-speakers earlier, collection of the data, make sure that you can ensure that it's authentic, ensure that it's safeguarded against corruption, make sure that you can track it in the form of a log, and make sure that it's presentable. Because even the best 3D model is no good or no better than a cartoon to the tribunal unless you've backed it up with an expert statement testifying to its legitimacy.
So then, Andrew, would you say that when one is considering all the benefits of AI and collection of data in these new and novel methods, one must also keep in mind the cost that's certainly going to be incurred when you're trying to get it independently verified, authenticated, because ultimately you also have to think about it from a dispute perspective and whether it's going to be admissible.
Absolutely. Cost is the driver. I mean, the construction industry is a cash industry. The margins are tight. you're not going to want to spend a large sum of money, especially if you're a small subconsultant or subcontractor. What I would like to see large projects do is that, similar to the document management system that is a cost often shared between multiple parties across large-scale infrastructure projects, why do we not adopt a similar approach to AI and the tracking of this type of data? So it's accessible to all, proportionate to your role on the project is the cost that you bear. But keeping in mind, one of my clients about a year ago lost about $150 million. This was prior to our involvement. We were brought in after the fact, thank goodness. But we couldn't undo the fact that they had not notified the employer of their claim. So they left $150 million on the table. For $150 million, they could have installed the best AI system with all the latest tech across all of their global projects and still been better off than losing on that particular claim. But one note of caution, and this is an exciting new world that we're entering. Will it make lawyers and delay analysts redundant? No, as has been said, it will not replace us, but it will refine what we can rely on and ultimately allow us to examine and explore things that we hadn't previously explored. But there are railguards in place, probably not as many as there should be. But one of the key issues we see time and time again by clients is the mistake of collecting this data without the appropriate approvals. So when you are presenting this data in cases, you should be wiping all personal data from the analysis. That's everything from the faces of the individuals caught on those drone footage to GPS locations. Because if you fall foul of a local law, which we had on a case where this data was being presented, it actually invalidated the analysis itself and killed it. So the other side couldn't rely on the data, and we just punctured that balloon very easily. There was nothing wrong with the data, but had been collated in violation of the law. So another thing just to keep in mind.
Interesting, thank you. My next question is for Amit. Amit, how do you collaborate with legal teams as a delay expert to ensure that your technical analysis aligns with their legal strategy? And what's the advice that you would give to other delay experts, maybe ones who are just starting their career?
Right. So, yeah, once, as Kunjan iterated and Andrew as well iterated that, getting in the experts at the beginning is one good way to strategize things. Because in my experience, since I've seen multiple occasions where I was involved in a matter, my very first matter, where I was given a storyline by the lawyers saying that, Amit, this is the case. And when I went back and studied the documents from scratch, I said, this is not your story, this is your story. And actually that went into the statement of claim. And the other experts also agreed most of the issues that we had raised. So which went into client's favor, which actually made the story stronger. Similarly, it's expert are not only for the disputes, but we can come as a help to avoid disputes altogether, where we come in to basically give you a very independent and objectivity. And that's the role, I think, as an expert, whoever wants to get into the field, that you must bring in your independence and objectivity, which is perhaps lacking in the dispute between the parties. Everyone wants to maximize their profits, and they are in their own battle. But that's where you are there to basically, assist the tribunal. That's one thing which I think, is missing in Indian construction arbitration space, that generally experts are believed to be hired guns. And probably, that's the perception that as a newcomer you would like to break into, because that's not the perception that international market has about the expert. And that's why you will see most of the appointments for the experts in the international space would come directly from the lawyers. They will bring in the experts to advise on the matters, to strategize, as Kunjan rightly said, to strategize the issue for them, to weed out the frivolous issue and focus only on the substantial matters. So that's the one thing which I think, as an expert, we are bringing in. And of course, as I spoke about, bringing in objectivity and independence helps to get and resolve the dispute even before getting into, before the award as well. That I've seen multiple times, that after the expert reports are filed in, parties have mediated and resolved the dispute before getting the arbitral award as well. So those are the things, those are the approaches I think helps the parties, even the council, to make the case to the client, to put forward a positive case to the clients as well. So yeah, that's how I think we come in to help to bring objectivity to the entire dispute.
Thank you. Unmesh, you spoke about the inward-looking approach and the outward-looking approach. So how do you think a party's approach to a contract affects delay? And could you tell us a bit more about these approaches that you spoke about?
Yeah, what I mentioned by inward-looking approach and outward-looking approach is if the project is an objective, completion of project in time is an objective. Because in construction industry, delays are inevitable, bound to happen, and it is not necessarily it will happen only from one party. It will be happen from either side, inevitably. So if your interest is to complete the project in time, the attempt will be made to resolve the issues at that instance when the situation has accrued, not waiting for stretching it to the end so that whosoever is in a stronger position will take a benefit. And that's exactly what the outward-looking approach is.
Right.
So if the objective is to complete the project in time, probably the contractor and the client both will be in an amicable position to resolve their time-related issues faster, because time and cost have a direct effect on quality. Nobody is going to work from his own pocket. So if I'm getting delayed for performance, and if I'm not being heard for, not being taken care of, obviously I'm going to compromise somewhere, because I'm not going to put any money from my own pocket.
Right.
That's what basically the inward and outward looking approach and the cost associated to it I want to refer about.
Thank you. Gunjan, we've talked, I think we've just touched upon the concept of concurrent delays. We also had this discussion earlier during which Dr. Lal said that he does not believe in concurrent delays. Could you tell me a bit more about concurrent delays and what is the legal standpoint on concurrent delays from an Indian perspective?
So actually, that's a very interesting question, especially from an Indian perspective. So, there are a couple of scattered judgments here and there which do talk about concurrent delays, but not a lot has been said, at least in the Indian scenario, about concurrent delays. If we talk about the SCL protocol, of course, it does define concurrent delays, wherein there are two or more effective causes of the delay, one at the contractor's risk and one at the employer's risk. But when we talk about concurrent delay in general, there's essentially two elements to be considered. And one is, of course, the extension of time element, and the other is the cost element, right? So if we talk about the Indian context, there is one stray judgment of 2019 of the Madras High Court, which sort of follows a Malmason approach, the UK approach, and which says that, okay, if there is a concurrent delay, even if part of it is an employer risk, a contractor risk event, then the contractor will still be entitled to extension of time. But as far as the costs are concerned, they would be awarded only if the contractor is able to show that, look, I would not have incurred the cost had it not been for the employer's delay. And then you need to cut out the contractor's delay out of that equation as such. And that is sort of followed in one 2019 stray judgment of the Madras High Court. And, when you come to sort of apportionment, again, not a lot has been said on that either. So there's a Delhi High Court judgment which talks about apportionment. And because there's not a lot of development on the concept of concurrent delays in India, the judgment doesn't do much on that aspect either. So this was a case where, the employer had caused a delay in sort of issuance of the good for construction drawings. And the contractor had also caused a delay, which was in supply of the materials. And there was a concurrency on that aspect sort of thing. And how the arbitral tribunal had dealt with it was simply by saying, look, I'm apportioning it 50-50. So if the claimant has sort of raised a claim of idling charges of, say, notionally 100 crores, then I'm just going to grant them 50%, saying that it was probably a notional amount of 50% of the idling charges which I'm going to award. And this sort of award was also upheld by the court. So, when as lawyers you're arguing on concurrent delay in India, you sort of build from first principles, and that's how you have to argue that. And of course, if you have a good baseline expert report to support you, so then that helps. But yes, as far as Indian scenario is concerned, there's a huge gap which still has to be filled, at least on the law.
But Gunjan, it kind of seems like, from what you told me, you've got the malmaison approach and the apportionment approach both kind of in operation in India. Is that correct?
That's true. So that's why I'm saying there isn't a uniform, consistent approach. And that's something which Mr. Pekam, I believe, mentioned right at the beginning, that, this is one of the problems which experts also face in the Indian scenario, is the lack of consistency. So I'm hoping we'll soon have a judgment on concurrent delays or apportionment, which sounds sort of reasonable and logical to go by. But until that happens, we are sort of building things up. That's where we are.
Thank you. And so my last question is for Andrew. Andrew, how do you manage cross-border disclosure of draft delay expert material? And where does the law stand on privilege and disclosure related issues? Because I'm sure you see a lot of these issues working out of the Middle East, projects happening everywhere, delay experts based everywhere.
It's a very pertinent issue that many people sort of gloss over. Lawyers obviously enjoy with their clients confidentiality and the attachment of legal privilege to their work product. And it's very rare for a court to try and override that, although some courts do have the power, interestingly. With experts, that privilege does extend to their draft reports. And again, we see this, a general understanding amongst most experts that their drafts, their inner workings, their notes on their Gantt charts, etc., emails, etc., with their team are not going to be disclosable. But that isn't a completely golden rule. In effect, depending on which jurisdiction you're in, you can find circumstances that will trigger disclosure of those draft reports. The case I mentioned earlier, the High Court case, dealt with the disclosure of the draft report as it pertained to the fact that it had legal counsel's comments on it. But if an expert actually take a different example where the expert references their previous drafts or some form of notes or meetings internally that they rely on in their final report, that does give the ability for the tribunal to trigger the automatic disclosure of that evidence. They will typically do so when they apply the sort of the best test principle, essentially to make sure that the disclosure of this material is relevant and material to the proceedings and will ultimately benefit the tribunal. They have to weigh fairness and equity. Sometimes both experts and counsel just make mistakes. They didn't mean to reference the previous draft, and it can be something as innocuous as a document number. I've seen it in circumstances where I've requested disclosure where the expert on the other side has referenced, version 3 of his report, and he's on version 6 by the time it reaches us. And we said, well, he's made reference to version 3, we should be allowed to see version 3. And the tribunal agreed with us. And the IBA affords the tribunal fairly broad powers in relation to this. So even when you're in a jurisdiction where the rule is quite clear, like take the laws in England, the DIFC and the ADGM, which follow English law, Singapore, which pretty much follows English law on this principle, where effectively there's a standard agreement that drafts are not disclosable. That doesn't necessarily stick if you're in a different legal jurisdiction where the seat of the arbitration is running a separate procedural law. For instance, under UE law, there is no hard and fast rule around this, nor is there in Saudi or in Qatar and Bahrain or Kuwait. But if a tribunal is particularly intrigued to see the underlying draft or the communications, then they can ask for them. And we had a really unfortunate situation where an expert had effectively made reference to drafts that his team had prepared, and we were able to force of those, and we saw very clearly that the expert had had little to no hand in the drafting of his report. It had been prepared by his team, which isn't unusual, but the expert usually briefed in relation to that work product, and in this case he had just copied and pasted it wholesale into his report. So just again, another note of caution when you're dealing with these things, particularly in the digital world where the analysis of metadata is becoming all too easy.
That's very interesting. Thank you. Do we have any questions from the audience? I think we've got time for one question, maybe. Okay. Okay, sorry. We don't have questions for time from the, we don't have time for
Saved by
questions
the
from the
bell.
audience. Oh, and we've also got tea waiting, so absolutely that takes priority. But if anybody has any questions for the panelists, please do reach out to them when you meet them outside. And thank you very much for your patience.
Thanks, Nikita. It was a very insightful debate-style discussion. May I request Mr. Rajiv Shankar Dwivedi to felicitate our guests? After the felicitation is over, we are breaking for high tea and will reassemble at 5:30. After that, we have two very important sessions left. Since we are running short of time, we are shortening those two sessions. We are making them half an hour each. The next two sessions are role of its claim quantification in construction disputes and laws of concurrent delays. So after the felicitation is over, request all of you to take your seat at 5:30. Thank you.